But at the end of the day, we've been talking a lot about acceptance already in the context of an offer. So let's talk about it a bit more. So, in order to reach an agreement, we need to have an offer. That offer needs to be accepted, and the acceptance needs to be communicated to the offeror. So it's pretty algorithmic again. An offer, the offer needs to be accepted while it's still open. The acceptance needs to be validly communicated, and then we have an agreement. So, all makes sense. So let's unpick what acceptance actually is. Acceptance is pretty simple, really. It is accepting the terms of the offer without any variation whatsoever. I'm talking here particularly about a bilateral contract. Why do I say without variation? Just saying yes to the offer is capable of acceptance of it on its term. Why can't you accept and vary the offer?
Because it's a counter-offer.
Because it's a counter-offer. It's a rejection of the offer if you're not actually accepting it as well. Something bouncing on the screen behind me. That yellow is quite annoying to look at, isn't it? I'm sorry about that. So Taylor and Johnson is a really useful case in this space. It's actually a relatively new case too for contract law, isn't it? 1983. Good case to read because it goes through each of the principles and the development of the principles themselves. And again, we use the objective test to determine whether or not both an offer has been made and whether it's been validly accepted. So Taylor and Johnson, I'm not going to go through the facts of it now. It is worth looking at. It is worth remembering that the end outcome of that case actually relates to a legal principle of mistake. And we're not covering that here. What I'm interested in this case for, from your point of view, is whether a valid offer was made and whether or not it was accepted and whether that acceptance was validly communicated. But when you read the case, you kind of you think, I want Mrs. Taylor to win. Is it Mrs. Taylor or Mrs. Johnson? I can never remember which way around the case. No, it's Mrs. Johnson. I want Mrs. Johnson to win. Now, Mr. Taylor's done the wrong thing here. Ultimately, she does win, but that's because of the mistake principle, not because of the way that the offer was made. So unpick it carefully when you have a look at it. Come on. So what kind of issues arise when we're looking at acceptance? Some of them on this slide. We've got to think about who can accept the offer. As a general rule, offers can only be accepted by the person to whom they were made. So unpicking, when you're looking at the facts, who was an offer made to? Was it made to the world? Or was it made to a specific person? Was it made to an entity or an organisation, either directly or through an agent of some sort? We need to unpick where and how we determine whether acceptance has actually happened and whether the acceptance needs to result in an actual meeting of the minds. So what happens when an offer is accepted but the parties still have different views as to what that means? We need to think about what happens if offerees accept when they're mistaken about what the terms of the offer are. Again, Taylor and Johnson is relevant there. And we need to look at the kinds of correspondence that go between the parties in order to work out which is the offer, which is the acceptance, and when the agreement is created. Some of the other things we need to think about with identifying acceptance is what kind of conduct can constitute acceptance. In particular, can silence alone be enough? What if silence is stipulated as the terms of the offer? So if I don't hear anything from you by next Wednesday, I'll consider it a done deal. Is silence in that circumstance acceptance?
I think it should be.
Pardon? You don't think it should be?
It's not.
It's not. You're right, it's not. So we use an objective test. You've got no way of knowing what somebody's doing if they're silent, but it doesn't have to be much more than silence. So shaking hands might be enough. A nod, a wink, a pat on the back might be enough. A tweet, an email, paying cash, all of those things that might be enough. You might not need to use any words at all, but silence alone is never going to be enough. And we need to ask ourselves how you can communicate acceptance. What's the general rule? How does the postal rule vary that? And I doubt we'll get to these rules this week. And what happens when we've got electronic communications in play? So let's have a look at this objective test approach. A court is going to ask whether a reasonable person would say that the parties intended to make an agreement. So, got them summarised here on one slide where I can, and I hope these help you navigate the scene. When we first read Carlyle and Carbolic Smoke Ball, one of the first things, I think it was Lord Wilberforce, says is an offer can only be accepted by the person to whom it is made. Then went and said, but it can be made to a class of persons, and if you fit within that class, and in this case it's an offer to the world, it can be accepted by members of the class. You need to have knowledge of and act in response to the offer. So the Queen and Clarke, you recognise that R stands for, I think it's Queen and Clarke, not the King and Clarke, but R for Regina or Rex. And so when we say it out loud, we tend to say the Queen or the King. That's a really good example of that. So you remember that from the casebook, I hope. That's the one where Mr. Clarke was, I think I've got it on a slide in a minute or two actually. Let's go back and talk about this one because I quite like this case. Where is he? Crown and Clarke is what they've decided to call it. Come on. So Mr. Clarke was assisting the police with their inquiries about a particular matter, and he was, it turns out that the police they'd publicised some information about a reward for information leading to the arrest of a criminal in a particular matter. Mr. Clarke was ushered down to the police station in relation to a completely different matter, and he was assisting the police with their inquiries, and it became very clear to him very quickly that if he were to offer up certain information, that he probably would have things go a lot easier for him in relation to the matter that he had been brought down to the station to address. Subsequently, he found out that there was a reward for this information that he handed over, which led to the arrest of his mate, and he went to apply for it. And the Crown said, well, no, we don't want to give it to you, you're a bad guy, effectively. He said, well, no, it's an offer. It was an offer to the world, just like Carlyle and Carbolic Smoke Ball was. Okay, I didn't happen to know about it at the time, but at the end of the day I did everything that was needed to be done. You owe me a reward. I think that's on the next slide, actually. Ultimately, he was unsuccessful in this. The legal point of order was effectively, you didn't know about it, you were not acting in consideration of the offer. Your acceptance was not consideration. Think about Mrs. Carlyle though. She wasn't taking flu medicine or the carbolic smoke ball to get 100 quid. She was taking that medicine to avoid getting the flu. But they said, well, you weren't doing that in relation, there was no consideration, but you were also unaware of the offer, and your conduct was not true acceptance. So what's the finding here? I think, so Justice Isaac says, acceptance is essential to contractual obligation because without it there is no agreement. And the absence of agreement, actual or imputed, there is no contract. A person accepting and performing must act on the offer. So another case in this space is the Woolen Mills case, which some students find really frustrating. So we spoke about that last week as well, that idea that there are these subsidies and you build your business around the subsidies and then they pull the subsidies away. How is that fair? And the principle in that case is the way that when you look at the conduct of the parties, there needs to be a bargain, that there needs to be an exchange. And we'll talk about this a lot more when we get into the consideration space. So I took myself off onto a little folly there as I wanted to talk about that. What are the ones? Let's get my little list of rules on acceptance. So acceptance needs to be communicated. You can communicate in any way. If the offer is very specific about how to communicate, then you need to communicate in the way that the offer says. But if it's not specific, then you need to communicate in a way that makes sense using the objective test. Acceptance occurs when and where the offeror receives or is deemed to receive the notification of acceptance. So that becomes particularly important when we're looking at international contracts. So Brink-Bon is the case that we use to illustrate that. It's quite old now because it's a case about telexes of all things, but it illustrates the point really well. What's hard when you're reading that case is to think, well, why does it matter where this contract was made? Why do I care whether it's in Austria or in London? The reason that they care is the laws of the place where the contract is formed will, in the absence of the contract itself saying what laws apply, will apply to dealing with disputes. So the outcome for the parties in relation to a dispute, if the laws of Austria would apply, would be quite different from if the rules of London were applied. So there are a couple of different issues in that case that they needed to unravel, which was both where and when. So we're talking about a telex, so at what time? Is it at the time it was sent or at the time that it was received? It's an instantaneous form of communication, so it was held to be at the time that it was sent. Sorry, no, instantaneous, at the time it's actually received. And then where? At the place that it was received. What else? So I'm just going to flick through for a second. I think as you're reading through these cases, it's worth noting that over a period of time, there's been a shift in the way, a very slow shift, but a shift nonetheless, in the way that the courts have taken this move from that subjective to a more objective test as to whether or not acceptance has occurred. So we started with a more, in some of the older cases, a more subjective approach where you could see that there was no contract until there was a real consensus between the parties. They're looking for a bargain of some sort. Where in the more recent cases, and Taylor and Johnson is a good example of that, it looks to this external test, this objective test. What would a third party having the same information, a person of reasonable intelligence, expect or understand based on the information that is available? And in fact, the next slide here has the quote on it, straight from the High Court. Would a reasonable person, having regard to their external manifestations of conduct, consider the parties to have reached agreement? In the slide pack you can see the facts of Taylor and Johnson. I don't intend to go through them now. I'm going to finish up because I am aware that people need to get trains. I just want to talk about this one. I kind of love this case because I just feel like I'm so Mrs. Chong. I am the person who would walk into Fitness First in January and sign up and then never go to the gym, which is a little bit sad, but anyway, it's true. So Mrs. Chong signed an application to join a gym. She signed a 12-month application. She didn't really read the terms and didn't realise that if she pulled out early that there was a withdrawal fee. She alleged that she was completely unaware of these terms, and she cancelled within 2 months, but she didn't want to pay the cancellation fee. So the question was, if she didn't know about the term, so even we don't need to worry about which was the offer and which was the acceptance here. An agreement was made at the point of the signing of the contract. It was most likely phrased that she made an offer and it was accepted by Fitness First. But the terms of that offer included this withdrawal fee, saying there's no meeting of the minds if I haven't been aware of that term. So what happened? What do you think? She had to pay. Why did she have to pay?
Because, I don't know, but I guess what more can Fitness First do? Like, if they have the terms.
It's actually based on a really old rule, and we'll look at the rule when we talk about formalities in particular. It comes from a case called Lestrange and Clarke. But essentially it's saying if you sign a document, then you should be held to the document that you sign. It's essentially the legal equivalent of, if you lead a horse to water, you can't make it drink. But at the end of the day, when we sign a document that looks like a contract, smells like a contract, then we should know that we're going to be held to the terms. And if we don't read it, then that's our problem. Now, there is, of course, a consumer law overlay here that deals with fairness of terms in contracts, etc. But the basic principle is, it doesn't matter whether there is an actual meeting of the minds or not. The external manifestation, based on the fact that you're prepared to sign a document, means it's reasonable for the other party to assume that that means that you're prepared to comply with the terms in that document, even if you haven't read them.